Tonight, we are very grateful to have a very astonishing and well-enriched expert in the field of intellectual property right. I ensure that our talk tonight will be enriching and fruitful, especially for students of law. So I invite everyone to stay on till the end of the program. Now, we shall call upon our esteemed resource person, Dr. Jupi Gogoi, who is currently working as an associate professor in the reputed National Law University and Judicial Academy, Assam. Dr. Jupi Gogoi has held the position of Assistant Professor of Law Regular at Faculty of Law, Delhi University from 2008 to 2021, and Assistant Professor of Law Regular at the Indian Law Institute, Delhi from 2012 to 2018. She completed her LLM from the Indian Law Institute with specialization in IPR and human rights law. She completed her PhD from Gujarat National Law University on the topic Protection of Agricultural and Natural Goods under the GI Act 1999, a social legal study with special reference to the state of Assam. She has made many academic contributions in critical areas of law, and her writings have found place in reputed journals and books, including CSIR Journal of IPR, Annual Survey of Indian Law, Journal of Indian Law Institute, Indian Law Review, Banaras Law Journal, and in editorials in leading newspapers like The Hindu and Assam Tribune. She has co-audited a book in IPR and human rights with special emphasis on India, and co-authored a book on a comparative study on ICT laws in India and Korea. She has the experience of teaching both PG and UG law students and has supervised 35 LLM dissertations. Yes, although there is a lot more to add, I shall end this introduction by saying that we are very grateful to have Dr. Jupi Gogoi to grace us in our humble platform tonight. And we will now invite her to give her presentation on Introduction to Copyright with special focus on right to education. Welcome, ma'am.
Thank you so much for the warm welcome extended to me. And good evening, everyone. Before I start, I would like to thank Mizoram Law College for providing me this opportunity to be amidst you all today. I especially thank the principal of the college and also my very good friend Rebecca for providing me this opportunity to have a small discussion with you on a very important topic, which I consider because, intellectual property rights is my specialization. I've been working in this area for some time. So I am very, very happy and very, very excited to be here amongst you all. And I hope, we have a good interaction today. Okay. So the topic of my presentation today, as you all might be aware already, is Introduction to Copyright with special focus on right to education, right? So this is the topic that I'm going to discuss today. But I would like to begin my lecture by discussing about intellectual property rights in general. And then I would like to, move on to the core topic, that is interlinking copyright with right to education. Right, so I will start my lecture today with a brief introduction to the concept of intellectual property, then move on to the core topic. Now, see, our lives actually are filled with products of human creativity. From the very time that we get up in the morning till we, sleep at night, if we minutely observe, we will see that, everything that is a part of our daily life is somewhere or the other a product of human creativity. So let's say we get up in the morning and we just look up, we see the lights in our room or a ceiling fan in our room, it just seems to be such simple things, that we have seen every day in our lives. But if you start thinking about it, you will observe that, this light that we are talking about, the ceiling fan we are talking about, has at one point of time not existed. And it was somebody in this world who put in their creativity, and invented a light for us, or, invented a ceiling fan for us, right? So in our household, from a carpet to a sofa, from the washing machine, the refrigerator that we use, the phone that we use, the music that we hear, the books that we read, the paintings that we have, the family photographs that we have. So everything, it is a product of human creativity, and intellectual property rights deal with this kind of creativity. And of course, the mobile phones which we use on a daily basis. I mean, mobile phones is a part of our regular life. It's not a luxury anymore. It's a necessity for us. So even this is again a creation of the human mind, and hence it is called intellectual property. Now, to define intellectual property would be that intellectual property rights are certain rights which are given to the creators of such work so that they are able to exploit commercially or otherwise their own creation without any interference from others. So I'll just help you understand this example by giving you a very simple, I'll give a very simple example to make you understand this definition of intellectual property rights. So let's say that I have written a book, So the moment that I have written a book, I have an intellectual property in the form of copyright over the book. And when I have a copyright in this particular book, it basically means that I am given certain rights under the Copyright Act of 1957. Now the question are, what are these kind of rights which are given to me? The rights which are given to me is that I will be able to exploit my work in a way that I'll be able to make money out of it, or I might be able to make other use of it. And while exercising my right over my book, nobody would be able to interfere with my right. Let's say I have a copyright over my book. I am the one to decide whether I will publish my book or not. Or if I decide to publish my book, I am the one to decide with whom I want to publish my book. Is it with the Oxford University Press that I want to publish the book? Is it with Eastern Book Company that I want to publish my book? Etc. etc. Now the thing is that Eastern Book Company or Oxford University Press will not be able to publish my book without my permission, because if they do so, it will be interference of my rights, and I can always take legal action against them. So intellectual property rights in simple term is this: it is certain rights, the right that is given to me as the creator of the work, as the creator of the book, so that I can exploit commercially, I can make money out of it because I have written my book. And this IPR ensures that others will not interfere with my work. And in case they interfere with my work, I will take legal actions against them. So this is, in simple words, the definition of intellectual property rights. Now, moving on, there are different forms of intellectual property rights, and basically post 1994, because in 1994, a very important international instrument came into being, that is the TRIPS agreement, the trade-related aspects of intellectual property rights. And as per the TRIPS agreement, intellectual property rights is classified into seven types. And the 7 types are patents. Patent is a kind of intellectual property right which is given for scientific inventions. I'm sure many of you know about it. Copyright. Copyright is another kind of intellectual property which is granted to, say, books, for literary work, for music, for dramas, for films, for sound recordings. The third is trademark. Trademark is another kind of intellectual property right which are given to a corporation. For example, Nike has a very unique trademark, that is their tick sign. So the moment you see a tick sign in front of a shop, you automatically know that it's a Nike showroom, right? So that is trademark. The fourth one is geographical indications. Darjeeling tea is a geographical indication. Assam tea is a geographical indication. From Mizoram, Mizo chilies are now a geographical indication, as well as Mizo puan is a geographical indication. So this is the fourth type of intellectual property rights. The fifth one is industrial designs. Now the thing is, what are industrial designs, and why is it an intellectual property rights? So when I say the word industrial design, we can talk about 2 examples. For example, a dress which is made by a designer. So that particular design is the intellectual product of a designer who is specialized in designing it. Now, I am somebody who is not into the fashion industry, or I am not somebody who has specialized in that particular area. So I will not be able to design a dress. So this is the creativity of somebody who has specialized in that area. So an industrial design will be given to the designer. In the same way, a design can be registered also to a car designer, right? So car designer, in the sense that when we look in the roads, we see different cars and every car has their own unique design, right? So industrial design is not only given to the designs of the designers, but it can also include the cars and other kind of, automobile designs, etc. The sixth kind of intellectual property, as you can see in the slide in front of you, is layout design of semiconductor circuit. On the face of it, it might seem like it's very complicated in intellectual property rights, but actually it's not. So I'll just give you an example. Let's say you have a phone, you have a smartphone, and your friend has another smartphone of another company. And let's say you have a third friend who has another smartphone, maybe of the same company as yours, but the model is different. Now, it is obvious that the camera of each of the phones are different. The features of each of the phone is different. So even in case of, let's say, I'm using a Redmi phone and Rebecca is using a Redmi phone. So, but our models are different. So the fact that our models are different, it would obviously mean that the features of our phones are also different. Maybe her camera is much better than mine. Maybe her phone has some special features that I don't have, etc., etc. Now you have to understand, you have to understand that this is because of many reasons. One, of course, the software in those phones are different. Secondly, you would know that there is something known as motherboard. A motherboard is there in a laptop. A motherboard is there in a phone. And if you actually open and look inside a motherboard, you will see small green colored three-dimensional figures. And these three-dimensional small figures in the motherboards are completely different in my phone. It will be completely different in your phone. It will be completely different in your friend's phone. And this design is made in such a way so that the desired result in the phone can be in a particular way. And because this particular designing of the semiconductor circuit cannot be done by anyone, but it can only be done by a person who is specialized in that area, and somebody, who is skilled or has a lot of creativity in that area, it is also considered to be another kind of intellectual property rights. Now, coming to the last intellectual property right, that is trade secrets or undisclosed information. Now, the thing is, what are trade secrets or undisclosed information? Let's say after your LLB, you join a company. You go to Bangalore, and you start joining a company, a law firm. Now, the moment you become an employee in the law firm, you will realize that you will have access to a lot of information of the company, which will include who are the potential clients of the company, etc., many kind of information. Now, the point is that the moment you will be an employee of that particular company, you have to sign a contract. And one of the provision of the contract that you will sign with your company would be that when you leave the company, whenever you want to leave the company, you will not disclose the secrets of the company to anybody else. And especially if you are joining a competitor company, you will not disclose this information, or else legal action will be taken against you, right? So because we do not have a legislation like the other intellectual property rights in India on trade secrets, but trade secrets as an intellectual property is usually protected under the contract law, right? So moving on, so this was just a broad, idea about the concept of intellectual property rights. I'm sure many of you know about it, but I could not start my lecture without giving you a brief background about intellectual property rights. Now moving on, coming to the topic, that is the topic of copyright. The thing is, for what category of work is copyright granted? So these are the 6 categories of work for which copyright is granted. This I have listed down. So copyright is granted for a literary work. Let's say you write a book, you will be granted a copyright on your book. Artistic work, let's say you make a painting, then you will have a copyright on your painting. Dramatic work, suppose you're writing a play for a theater, then it will be a dramatic work, you'll get a copyright over your dramatic work. Suppose you are a composer who is composing a piece of music, so you will be given a copyright on your musical work. The 5th one, suppose you are a producer of a film and you're making a film. So the moment your film is made, you will get a copyright over your film. The last one, suppose you're making a sound recording. So the moment you make your sound recording, you will have a copyright on your sound recording. So these are the 6 categories of work for which copyright as an intellectual property rights will be granted to you. And the copyright symbol is a C with a circle. So many a times when you will be going to different websites, at the bottom of the page, you will see a symbol C with a circle. It is nothing but an indication which states that it is a copyright protected work. So whenever there is copyright protected, you will see the symbol C with a circle. Okay, now moving on. What are the rights that you are granted under the copyright law? So this is something that you need to know. Now, basically, when I write a book, right, I'm the copyright owner of the book. So the thing is that what are the rights that I get under the Copyright Act or under the copyright law? So under the copyright law, usually the right that I get is that, let's say I have written a book today. Today is 25th of February, 2022. And let's say I live for another 10 years. That is, I live till 25th February, 2032. So I will have a copyright over my book during my lifetime, that is till 25th February 2032, plus another 60 years. Another 60 years means 2032 plus 60, that is 2092. So if I write a book today and I die in the next 10 years, the copyright for my book will be my lifetime plus another 60 years. And during that span of time, I or my successors will be able to exploit my creation, right? So let's say I've given an example. If you write a novel, under the copyright law, you need to know what kind of rights you will have. So if you write a novel, let's say, you will decide who will publish it. Whether you want to publish your book, that you will decide. Who will publish your book, that you will decide. For how much money will you give the publisher to publish the book, that you will decide. So these are many of the rights that you will be given as a copyright owner. Let's say you write a beautiful story, right? And there is a producer of a film who becomes very, very interested now in making a film based on your novel. The producer of the film will not be able to make it into a movie without your permission. Because when you write a book, you will also have filmmaking rights on your book. So if a producer wants to make a movie based on your book, the producer of the film has to approach you, take your permission, and make the movie. In case the producer does not take your permission while making the movie, you can always file infringement case against that particular movie producer, right? The last point, registration under the copyright law is not compulsory. If you create a copyrighted work, you are the owner irrespective of registration or not. So what does it actually mean? It actually means that today I'm sitting in this particular room in my house and right now it's raining outside and I'm writing a poem. So the moment I finish writing my poem, I get a copyright on my poem. Whether I file for an application for registration of copyright or I don't, it doesn't really matter. But the moment that I write a poem sitting in my room here, the result of my own creativity, I get a copyright automatically on my poem, right? Now, then you will ask, what is the point of copyright law? Then what is the point of registering the copyright law? You have to understand we are law students, so we have to be smart and we know how to protect our work, right? So if there is a client who is coming to you and your client is asking that I have written a poem yesterday, And will the copyright be with me? If I don't register the copyright, will something happen? Should I register the copyright, etc., etc.? So the answer to that question would be that, see, the moment you have written your poem yesterday, you have a copyright on the poem, definitely. But as a lawyer, I would suggest that you register it so that if tomorrow there is another poem, a person who claims that he is actually the poet of this poem, so that you have certain evidence in the form of registration. You have a registration certificate, you can show it before the court that this is the evidence that you are actually the poet of the poem. So as a lawyer, you will say, for the safer side, you can register it so that if there is tomorrow a controversy, you have a piece of evidence. But if you are asking as per the law, it is not mandatory to actually register your poem, right? Okay, moving on. Now, voluntary and non-voluntary licenses. This is something that we need to understand. Now, the thing is that, let's say again, you have written a novel, right? You have written a book. So, you have the right to exploit your work. You have the right to make money out of the book that you have written, right? So, how can you make money out of it? You can sell it to a publisher, and the publisher will publish your book, and the publisher will give you the royalty, the money that he earns from publishing your book, some share of it, right? Now, this is a thing of voluntary licensing, that the publisher approached you that I want to publish your book. You enter a contract with the publisher, give him the rights to publish the book, and he gives you money in return. So this is a question of voluntary licensing, right? Because you have on your own given the right of publishing the book to the publisher. But the thing is that, what is compulsory licensing? So you have to understand that compulsory licensing is a kind of non-voluntary licensing. That is, you do not want to give the license, but because the government wants you, or because of some other strange circumstances, you are forced to, to give your book to somebody. Now the thing is that, I can cite you an example of compulsory licensing. Let's say, let's say a person A writes a book on mathematics. Now he has a publisher. Let's say ZY publisher. A is the author of the mathematics book. ZY is the publisher of the book. Now, what has happened is, for 10 years, they published this book. It became very important for the students who appear for the 10th board exams to actually refer to this mathematics book. But after 10 years, what the publisher of this book states is that we are not able to make so much of money on this particular book, so we will stop publishing this book altogether. Because we are not making money, what's the point in publishing this particular book? So they stop publishing this book. The very next year, what happens is the 10th board exams are coming, and students now desperately need the book, but they are not able to buy the book because the publisher has stopped publication of the book, right? So it's a public interest question. The students want the book, they are running from here to there finding the book, but they are not able to find the book because the publisher has stopped publishing it. So let's say I have a publishing house, right? I go to the government. I tell the government that students for their 10th board exams need this particular book. The publisher is not publishing this particular book. Can you allow me to publish this book by giving me a compulsory licensing, right? So the government looks into the issue, realizes, yes, the student needs the book and they're not getting the book, and then says, okay, we are giving you a voluntary licensing and non-voluntary, a compulsory licensing, a non-voluntary licensing, that you will publish the book now and you will make it available to the students, right? Why is it non-voluntary licensing? Why is it compulsory licensing? Because here I have not taken the permission of the copyright owner to write the book, right? I have not taken their permission. I have gone to the government, and the government has said, you both have been bad. You are not making this book available to the students. She wants to make it available to the students. So I will allow her, whether you as a copyright owner gives her the permission or not, I don't care. But I as the government will give her the permission now to publish the book for the students. So you have to understand this particular distinction between voluntary and non-voluntary licensing under copyright law. And of course, if you have any doubts or questions after the end of the lecture, you can definitely ask me. So, okay, so moving on. Now, many of you might be thinking or wondering, why am I talking about the concept of social justice when I'm talking about, copyright law? Because we are not just talking about copyright law, but the lecture today is copyright with special focus on right to education. So it becomes very important for us to understand the social justice concept and, right to education as a fundamental human right, so that we have to follow it. Right? Now, the thing is that many of you, I'm sure, would know what is social justice. Social justice is a concept, a theory, a philosophy which focuses on the concept of fairness. Fairness in the sense that there should be equal opportunity for everyone, irrespective of whether somebody is rich, somebody is poor. Just because somebody is rich, they're getting something, and because somebody is poor, they're not getting education. That's a very unfair system. You cannot call it social justice, right? Now, some of the important principles of social justice includes access to resources, equity, not equality, but equity, participation, and human rights, right? Now, just a second, I'll just go to the next slide. So basically, access to resource is a very important social justice concept and refers to the extent to which different socio-economic groups receive equal access to give everyone an equal start in life. Now see, access to resource is very important for the overall development of the human being. Now if we talk about education, education is something which should be accessible to everyone in the society. Education is not only a way to get a job. It not only paves a way for employment, but it also makes us aware as citizens whether something wrong has been done to me, is something evil being done to me. So education is not only a ticket for us to get a job, but education is also something that makes us aware as a citizen who can work for the welfare of the society. Ultimately, all laws, everything should be for the welfare of the society. And if education as a resource is only accessible to the rich and not accessible to the poor, that is not a welfare state. That is not how the society should be. So, right to education for all sections of the society is a very, very important human right. So, moving on, as we have understood that education and accessibility of education is a basic human right, it's one of the principles of social justice, we need to understand, is there a correlationship or an interrelationship between copyright and education, right? And we have to also analyze whether copyright law works for accessing education to all, or copyright law is used as a medium of, providing education only to the rich and denying education to the poor. So my area is, this is the area that I want to focus on my lecture today. Definitely there is an interrelationship between copyright and education. Why? Because of some of the important subject matter of copyright includes literary, artistic, dramatic films and sound recordings. And as you can see, the first subject matter is literary work. So the moment I say literary work, it includes books, it includes poems, it includes any other kind of example of literary work that you can think about. So as students, from the education purpose, literary work or books are very, very important. So definitely copyright and education has a very important interrelationship. Now, the moment, let's say, somebody has created a literary work in the form of a book, we need to first understand what are the major rights the person will get under the copyright law. The first right that the person will get will be to reproduce the work. The point is, what do we mean by reproducing the work? It means that if I have written a book, I will decide, I am the one to decide if I want to make more copies of the work, right? Let's say, I have one copy of the book, whether I want to make 100 copies of the book, whether I want to reproduce my book for 200 times or 1000 times, it is it is on me to decide. I am the one to decide because I have the reproduction rights. The second one is to issue copies of the work to public. It means whether I want to publish my work or not publish my work. So let's say I have written a novel. It's not, nobody can force me to publish my work, right? So if I write a book and I just don't want to publish it, I don't want to share it with the world, it's up to me. But if I want to publish my book, it will be the second right that I will be exercising, that is to issue copies of the work to the public. The third one is make a cinematograph, film, or sound recording. That means that the moment I write a literary work, a book, I have movie making rights on my book. So let's say a producer of the film wants to make a movie based on my book. They have to take my permission because I have the film making rights. So if they make a movie based on my book without my permission, it's an infringement of my film making rights. In the same way, sound recording, let's say I wrote a poem. Now somebody wants to sing a song based on the poem, they want to convert it to a song, my poem to a song. So I am the one to decide whether I will give the rights to the other person to convert my, my poem to a song or not, right? Then fourth one is translation of the work. So let's say I have written a work in English. Now, let's say somebody amongst you wants to translate my work in Mizoram, right? So you have to take my permission because I have a copyright for the translation of my work. So if you convert it to Mizo without my permission, it will be an infringement of my rights. And the last one is to make any adaptation of the work, which is, I'll give you an example. Let's say, you know about dramas, right? The theaters that we have, the plays in the theater. Suppose I write a book and somebody wants to make a drama based on my book. So it will be an adaptation of my work. So even that they cannot do without my permission because my right under copyright include my right to adapt my work to different forms. So these are the major kind of copyright rights which we get as a copyright holder. Now coming to the core question, is copyright a promoter of education or it is a hindrance to education? Now you have to understand that the fact that I am a copyright owner, I get certain rights, and one of the rights that I get is to file infringement cases. When can I file an infringement case? When any of the work that I just mentioned, these are the work, let's say when I write a book, so these are the rights which I have. If any of this work is done without my permission, somebody makes 100 copies of my book, somebody makes a film, somebody translates my book or makes a drama out of my book without my permission, it's an infringement under section 51A1 of the Copyright Act. So this is the first right that I get as a copyright owner. Now there are also exceptions to this infringement. That is, what are these exceptions? Let's say somebody, in a normal circumstances cannot reproduce my work. Let's say somebody cannot photocopy a work of mine. I wrote, let's say, in one article, and somebody wants to now make a photocopy of my article. The thing is that the right of reproduction, because photocopying is what? Is reproducing. You are making a copy of my work. So that right is of me. So let's say if you are making a photocopy of my work, so we have to understand whether it will be an infringement or it will not be an infringement. Because I'm sure many of you, while taking your classes, you get back and you photocopy a lot of things. So, and it's part of your education, right? So a very important answer to the question that you need to know is when you're photocopying something for studying at your home, because you all are LLB students, are you doing something right by the law or are you committing a copyright infringement? Because I'm sure the article or the book that you have photocopied, the copyright lies with somebody else, right? So these are the kind of questions, the answers to which we are trying to explore in this lecture today, right? So you have to understand that there are certain exceptions to copyright, and the thing is that in normal circumstances, photocopying of a work is not permitted because it is infringement of the reproduction right. But we also need to understand that it cannot be that we all as students, you all as students are committing infringement. It cannot be so, right? The question is why it will not be so, because it will come under this category of exceptions to infringement, that in normal circumstances it will be infringement, but because it's not in normal circumstances, you are students, you need it for your education, probably what you are doing will not be an infringement. Now we need to understand under the copyright law, what are these exceptions, for education, right? So we will just discuss about it. The first provision that we will discuss is section 52(1)(I). Section 52(1)(I) is, let's say you're reproducing or photocopying a book, but the photocopying of the book is done by a teacher or a pupil in the course of instruction. It will not be an infringement because it will be considered to be a fair use. Suppose, think of a very odd situation, Suppose one of you have a photographic memory. You read a paragraph, you can write the paragraph in a answer sheet without even missing a comma or a full stop. Now, it means that you are exactly copying the work, the paragraph of the book in the answer sheet. Think of a situation that paragraph is written by a particular author, right? So it is the copyright of a particular author. The moment you have a photographic memory, there's a question which came in your exam. You remember everything with a comma and a full stop. You wrote it down. A copyright case is filed against you. Why? Because you have reproduced the work exactly as the author of the book has written, right? Wouldn't it be very absurd, right? How can it be an infringement? You are a student, you have read it, you have remembered it, you have reproduced it in an exam. So that cannot be an infringement, right? Because you as students have a fair use to write any literary work as part of answers in your examination, right? So the next one is fair dealing for the purpose of private or personal use, including research. Now let's say somebody is doing a PhD. And of course, when you're doing your PhD, you have to read a lot of books, you have to read a lot of articles. You cannot possibly buy all these books and buy all these articles, right? So what do you obviously do? You photocopy a lot of this work. Now think of a situation that the PhD scholar has been filed an infringement case because the PhD scholar has actually photocopied these books and photocopied these articles, right? But this particular PhD scholar can save himself or herself because section 52(1)(A) is there. Because section 52(1)(A) states that if somebody is using a copyrighted work, that is a book or an article, for the purpose of private or personal use, including research, it will not be considered an infringement. So you can very safely photocopy a work and don't worry about getting infringement charges because you are doing it only for your personal use. You are not going to sell it and make money out of it. So you are safe that way. Now, coming to section 52(1)(H), it's very interesting. If you remember in school, when you used to study, let's say English literature in school, you used to get this textbook, which includes, let's say, 10 chapters, and it is different stories by different authors. Let's say Guy de Maupassant, one chapter of Shakespeare, one chapter of one chapter of some Jane Eyre, something of that sort. So you have all these stories compiled together in your English textbook, and then you have poetry also. So the poems will be of different poets. One is William Wordsworth's poem. Another poem is of another person. So the thing is that these are all copyrighted work. Because let's say one story is by Guy de Maupassant, a French author. The second one is, let's say, it is by another author. So the thing is that when you are including or publishing these, taking these stories of different authors and poems of different poets together, and you're publishing it, is there a question of infringement? Yes and no, both. Now, usually what happens is most of the stories that are included in our textbooks in schools, let's say, William Wordsworth work, let's say, is included in your syllabus, and there is a textbook where William Shakespeare's work is included. It is usually not copyright infringement because the copyright is over, because it is more than 60 years since William Shakespeare has died today, right? So as I told you, a copyright is only 60 years after your death. So you don't have to be worried about. But the problem is that, let's say the author is alive or the copyright is in existence, then what? Then section 52(1)(h) says that if you only publish two passages from the work by the same author during any 5 years, it will not be infringement. But if you are publishing more than two passages, it will be considered to be an infringement. So this is important. Now, I'm so sorry. Yeah, the next one is for library use. Let's say, there is only one copy of a book in the library, and the librarian feels that, let's say, some student takes the book for some reason, does not return it back, and the student has lost it. And the library had only one copy of the book, and let's say the cost of the book was 50,000 rupees. So library, has limited funds, so they cannot procure another book. Now, in that particular situation, if the library, makes a scanned copy of the book and keep it, scanned copy is a reproduction. Please remember, it's reproduction, right? It's like photocopying. So if the library is keeping a scanned copy and keeping it, it's not an infringement because it comes under fair use under section 52(1)(n). In the same way, 52(1)(o) says that it's another library exception. Let's say a book is not commercially available in India. This book has been brought to the library, let's say from a foreign country. Now the librarian of the book makes 3 copies of the book. They makes 3 photocopies of the book or 3 scanned copies of the book, and keeps it in their non-commercial public library. That will be not considered to be infringement. So you have to understand, why am I discussing this? I'm discussing these because these are important. These are important exceptions, or these are important fair use concepts from the perspective of right to education, right? Also, before I continue, how much more time do I have?
Ma'am, you can carry on.
Okay, thank you so much. Thank you so much. Then I won't be too worried about it. Okay, so this going with this whole thing, this debate about right to education and right to education and copyright, I want to discuss a very, very important and very interesting case that happened. And this is not just a case pertaining to Delhi University, but it's a case against the entire student community and academic community of India. Now, many of you might be aware that there is a department in Delhi University known as Delhi School of Economics, right? Now, what used to happen in Delhi School of Economics, that, these professors who teachers in Delhi School of Economics, they used to prepare course packs in the sense that, let's say, for the lecture, for this semester, each professor, let's say, of one subject, would find out articles which are important for the syllabus, compile them together, and make a course pack, that this course pack will be useful for the students, right? Now, within the campus of Delhi School of Economics, there was a photocopy guy known as Rameshwari Photocopy Services. Now, these professors, what they used to do is, they used to collect different articles, compile them together, put them together for the benefit of the students of every semester, give it to this guy in the campus, this photocopy guy, and tell this photocopy guy that you please provide this to the students. Okay, this course pack is important for the semester, please provide it to the students. And this photocopy person used to supply it to the students and used to charge 50 paisa per page, right? Now, there Oxford University Press, Cambridge University Press, Francis and Taylor, some of the big shots in the publishing industry from abroad, filed a case against this Rameshwari Photocopy Services located in Delhi School of Economics, as well as against Delhi University, stating that what they were doing is an infringement of their copyright. Now, what are the specific allegations that they said was that these course packs were used like textbooks and hence were competing with the publications of the plaintiff, right? So they were saying, we are publishers of these books. These articles are from our books. They are taking these articles, compiling them, photocopying them. So it is being used as textbook, and it is competing with our work, and it's an infringement. Now, they also said that Rameshwari Photocopy Services is charging 40-50 paisa per page, whereas if you go outside, a photocopy guy is charging only 20-25 paisa per page. And the only reason Rameshwari Photocopy Service is doing it is because they want to make more profits out of it, right? Now they said that they already knew, they were very smart people. Obviously, you know, these big publishers would have very big lawyers with them. So they already knew that the Delhi University and this photocopy person would take this plea, that this photocopy is nothing but reproduction of a literary work by a teacher or a pupil in the course of instruction. So they knew that they will take this particular plea. So the plaintiff, that is these publishers, they said that this particular provision, section 52(1)(I), will not be applicable, since reproduction by Rameshwari Photocopy Services with the assistance of Delhi School of Economics could not be classified as reproduction by a teacher or a pupil in the course of instruction. So what did they mean by it? They meant that, see, this photocopy is not provided in the classrooms. It's not provided in the lectures. So these students used to come out of their lectures, go to this photocopy guy, ask him to get a photocopy, and they'll get a copy of it. So this is not in the course of instruction. They're saying that this is not provided in the classroom, but this is happening outside the classroom, and hence section 52(1)(I) will not be applicable, because section 52(1)(I) talks about in the course of instruction, in the classrooms. Because it is not in the classroom, it is infringement. Had it been in the classroom, it will be fair use, not infringement, exception to infringement. But because it is happening outside the classroom, it's an infringement. Also, they said that if at all this could be allowed, then section 52(1)(H) will be applicable. That is, only 2 paragraphs could be published, you know. 2 paragraphs from our article could be used, not more than that, because section 52(1)(H) provides that if you are taking from a copyrighted work, you cannot take more than 2 passages, right? So they said, but since they are taking our whole articles, our whole books, this is a complete copyright infringement. It does not come under fair use, or it doesn't come under exceptions to infringement. Now we have to interestingly understand what Delhi University and Rameshwari Photocopy Services people had to say. Now, Delhi University and Rameshwari Photocopy Services said that this is fair use. This is completely fair use as per section 52 of the Copyright Act. Rameshwari Photocopy Services said, and they were rightly so. Now, please try to understand the situation. The books of Oxford University Press, Cambridge University Press, you know, they are not cheap books. One book would cost more than 50,000. Some books might be more expensive, it may be 1 lakh rupees. Now tell me, in reality, in practice, can Indian students afford this book? I mean, people who are working, middle class people who are working cannot afford these books. We can't even talk of the students. The students obviously cannot buy these particular books to read them. And let's say you can buy 1 book. Somebody is reached, it's kind of middle class, buy 1 book, but you need 7 books. Will you be able to buy 7 books? So these publishers said that these are like textbook and they are competitors. But Rameshwari Photocopy Services said that how can we be their competitor? We are photocopy services, they are publishers. You know, students who are very rich, who can buy these particular books, will buy these books. But most of our students cannot afford their books. Hence, they come to a photocopy shop and make photocopies of our book. So these students who do not have the money to buy the books, how can they be potential consumers? You can be potential consumers when you can afford to buy something. So these students who come to us cannot afford to buy your books. So how can we be competitors, right? And absolutely so. Most students cannot buy this book. So how can, you know, these publishers say that these students, so because this photocopy is done, we are losing our consumers. How can it be so? You know, these students who are photocopying this book cannot be the consumers. They cannot buy this book, right? So the publisher's conception is entirely wrong, that they are losing consumers. They are not losing consumers, because these students in normal circumstances also cannot afford to buy this book. But the question remains, just because they cannot afford to buy this book, should it be that this book should not be made available to them, right? So again comes the same important fundamental question: should education be only for the elites, that is for the rich people? Should education be something unaffordable to the poor people? There lies the important question. Now, Delhi University categorically said in their defense that Section 52(1)(I) is applicable during the course of instruction if a teacher or a student is reproducing or photocopying the work. It is not an infringement. And to what extent are they photocopying 1 page, 10 page, or 50 page? Doesn't matter. If it is for educational purpose in the course of instruction, it is coming under fair use. And they said that the word which is used in section 51A, please pay attention everybody, in the course of instruction, the Delhi University said that they are not talking just about classrooms. Suppose you are studying in a particular semester. Is your classroom lectures enough? It's not enough. You have to do readings, right? Your entire, and you will be given marks based on what you write in the exams, right? Or the internal assessments that you will be a part of. So in the course of instruction is not only the classroom lectures, but it is much more. So anything that happens in the course of the semester, including the classroom lectures, form in the course of instruction. So they're saying that students, after the classroom lecture is over, their education or their course of instruction doesn't stop. Their course of instruction, it continues even after the lectures are over. They have to, after the lectures are over, the teacher will give 5 references. Read these articles, read these books, right? So until and unless they go and read this book, they read these articles, their instruction is not over. So Delhi University basically stated that the wording which is used in the provision is not in the course of lecture, but in the course of instruction. And instruction doesn't end only with classrooms. It is much beyond that, right? The next one is that they said that instruction could not just be limited to in the classrooms only. It has to include other forms of instructions as well. So now we need to understand what is the decision in this particular case. So in this particular case, the basic decision is that, the decision is that in 2012 first, what they did was, Delhi High Court said that whatever Rameshwari Services is doing, they have no right to do it. They have to stop selling the course materials, right? There was a huge hue and cry in India. It means this decision of the Delhi High Court was meant that education is something which will not be accessible to the poor population. It is something only for the rich population, right? So there was a lot of criticism. Many teachers, academicians, professors, many social reformists, they came forward. They said this is absolutely wrong. We cannot do against this particular. We have to go against this particular decision of the Delhi High Court. Delhi High Court cannot make education unaffordable to these students, right? So the matter reopened, right? In 2016, there was a single judge bench decision, and the decision was given by Justice Rajiv Sahai and Law. And Justice Rajiv Sahai and Law dismissed the petition and said that you publishers have no right to file this particular case because Section 52 allows the students to photocopy the work for their educational purposes. Now, whatever the students of Delhi University, the professors as well as students were doing was completely fair use, not infringement, because what they were doing was photocopying in the course of instruction. They were doing it for educational purpose. They were not doing it for commercial purpose. Hence, it's not an infringement, but it is a fair use, right? Justice Enlaw also said that the aim of copyright was to encourage knowledge, not to stop knowledge, right? The legislature did not use the lecture deliberately. Had it used the word lecture, means it would be classroom lecture. Now, because the word instruction is there, it cannot be narrowed down just to mean lectures, right? So they are saying, since photocopying or clicking pictures of book was not against the law, photocopying by a shop as instructed by the university for the benefit of the students cannot be a copyright infringement, right? Now we thought that students won, but it has not been so. The matter was further appealed by these publishers because they were not happy again before the division bench of the Delhi High Court. Now, division bench of the Delhi High Court gave a decision, and the final decision is not yet given, but the decision is not completely in favor of Delhi University and the students, nor against them also. We just need to know what is the part of the decision. First, they said that Justice Enlaw's decision is wrong because Justice Enlaw dismissed the publisher's petition, said that you have no right to file this infringement case. Division High Court said that no, there are legal issues in this particular case, so we are reopening the case. But they said that till the decision of the case is not given, we will not stop Rameshwari photocopy from photocopying the work. So only when we give the final decision, then we will decide whether photocopying will be allowed or not allowed. But for now, we will not, we will not give any stay order for them. But a very important observation was made by the Delhi High Court in this particular division court appeal. They said that, as long as photocopying is done strictly for educational needs, not for anything but educational needs, it will be allowed. But if it goes beyond educational needs, then it will be considered to be an infringement, right? So the question which is remaining undecided yet is the course specs which were made, whether it was only for educational need, whether it could be permitted, because there has been allegation by the publishers that complete full books have been published, right? So the Delhi High Court has not yet decided, right, that whether full books can be photocopied or not, because it's a very important question. Photocopying one chapter is a different thing, but photocopying the entire book is a different thing altogether, right? So Delhi High Court said that we are not dismissing the petition, we are leaving these questions open, and later we will decide. Thankfully, up till now, till 2022, till 2022, the further appeal has not gone, because it has created a kind of protest wave, not only in India, everywhere in the world. Not only students of India has fought against it, or the academics in India has fought against it. Even the students and professors of Oxford University has written to Oxford University Press that please drop the charges, don't go for a further appeal. Law cannot be tilted so that education is only affordable to only the rich people. Students in India cannot afford these books. So if they're photocopying this work, please allow them to photocopy this work. Do not make a further appeal, right? So till now, these publishers have not gone for a further appeal, but let us see in future what they do, because this is a very, very crucial question that we are dealing with here, right? Now, before I wind up my lecture, I cannot wind up without talking about this very, very interesting concept, right? Which is known as the concept of Creative Commons related to copyright and education, right? Now, I'll give you an example. If I write a book, let's say I write a book, I hope I can write a book someday. Let's see. So if I write a book, my purpose of writing the book will not only be about earning money, right? And that is what is in the minds of most readers, because most writers, they don't write just to make money, but they also write because they want to make their work available to a wider audience. They want people to read their work, right? Now, let's say I have so much of rights, when I write a book, I start thinking, what will I do? I'll give you a very practical example. When if I write a book today, I will get a copyright for 10 more years till I die, and for 60 years after I die. Do I need that much of a copyright? If I have put in my hard labor and I am able to earn out of my book, it's okay. But after my death, for another 60 years, there will be copyright. It means my children and my grandchildren can eat out of the money from my book. Why? That is a very important question. Why I will provide my children with education, with whatever needs is required. Let them earn their own living. If they cannot earn on their own after giving them an education, it's their problem. But so much of copyright is it required? I only need, when I write a book, that my work be read by people, and if somebody is using my work, please acknowledge my work. Please acknowledge that this thought which has come to my mind has come from Jupi Gogoi. That is all I want. I don't want these reproduction rights, translation rights, this right, that right, so much of infringement right. I just want you read my work. If you are using my work, kindly acknowledge my work. So this was not only the thought of 1-2 people, but a lot of people, started feeling angry because they are the authors, they are the writers, but they don't want so much of rights. Now, there was a professor in Stanford Law School known as Professor Lawrence Lessig, who started a movement called the Creative Commons movement, which states that I will write the book, I will have some copyright, but I don't want so much of copyright. So they are like, if I write a book, you cannot use my book without my permission, but you cannot use my book without removing my name. But let's say you publish my book and earn money out of it, there is no problem. I'll just give you an example. I write a 20-page short story, and my point of the 20-page short story is that people read my story. Okay, now I just want that if you are using my work, or if you are selling my work, just don't remove my name as the author of the book, don't put your name as the author of the book. But if you want to make 50 copies and 100 copies and sell it at 100 rupees per copy, I don't have a problem. You can make money out of my book also, I have no problem. But don't remove me as the author of my own work, because writing a book is also like my baby. So if I have a baby, I would always want that I am the parent of that particular baby. So if I have written a book, I am the parent of the book. You have no right to remove my name as the parent of the book. So that's all that I want. So these people, this Creative Commons movement stated that we don't want very strict copyright law, we need some rights. So what we will do is we will write down and mention what copyright we want and what we do not want. So this Creative Commons license, there are many types of Creative Commons license which an author can decide to take, and if they don't want the entire copyright regime. So one type of license is the CC BY license. So this is the symbol of the CC BY license. So in CC BY license, what happens is, let's say I write a book. Suppose you are taking my work. Let's say I have written a poem of 10 paragraphs. Now this CC BY license gives you the right to build upon my material. That is, you can add another paragraph to my poem and publish my poem, but my name should be there as the poet of this poem, and you can sell my poems, let's say at 1,000 rupees. I have no problem, because CC BY license means CC means Creative Commons, BY license means that you cannot remove my work as the poet of this poem, but you have every other right to use my poem. If somebody wants to recite my poem in a platform, no problem. You want to recite my poem in a class, no problem. You want to add another paragraph to my poem, no problem. You want to sell my poem and make 1,000 copies of my poem and charge 1,000 rupees per copy, no problem. But you cannot remove my name as the poet of this particular poem. So this is one kind of Creative Commons license. Now, there is another kind, so there are many, I'm just dealing with two right now. One is Creative Commons BY-NC license. It means that I have written a poem, you can distribute my poem, you can use it in my classroom, recite it in your classroom, you can recite my poem in a stage, no problem. You can add another paragraph to my poem, no problem. But you can use it only for non-commercial purposes. Let's say you want to now sell my poem. You cannot sell my poem, but you want to add another paragraph to my poem, you can add, no problem. You have a classroom, you are an English teacher, you want to distribute my poem in your class because you want to teach my poem in your class. I have no problem if you make 1,000 copies also, because I am taking BY-NC license, right? Which says that I can for non-commercial purpose, you can use the poem the way you want. There is absolutely no problem, but you cannot remove my name as the creator of this particular poem. Now, it might seem a little complicated for you all, so I would like to just simplify. This Creative Commons license is taken by people because they are frustrated or angry with the copyright system. They're saying that copyright granting is okay, but we do not need so much of rights. I have written a book because I want people to read the book. I have written a poem because I want people to read the poem. I don't want thousands rights over it, but I want just a simple right. that if you are using my work, or you please don't remove my name as the writer of the book or poet of the poem. If you want to make commercial money out of my poem, you can do so, right? But some people may be different. They are like, okay, I have written a book or I have written a poem. You can use my poem, don't remove my name, but don't use it for commercial purpose. You want to make money, not my poem, right? Only what you can do with my poem is in your classroom you want to recite, any non-commercial purpose you want to do, it's okay, but not for commercial purpose. Now the thing is that, does it practically happen? Absolutely. These licenses are practically taken. I will just show you this example and please look at it carefully. I'm sure many of you watch YouTube videos, right? So I was watching a YouTube video known as Foundations of Copyright Law lecture. Okay. Now this is the person, William Fisher, who has uploaded this video in YouTube. Now he has mentioned here, please note everybody, it is Creative Commons Attribution License Reuse Allowed. So this person is unhappy with the copyright regime because it feels that if I have created somebody, why should it not be accessible to everybody? It should be accessible to everybody. Let's say this is a lecture, you want to reuse my lecture in your lecture. No problem. You can reuse my lecture, right? Or maybe you want to make a CD, with 10 different lectures, and you want to include my lecture also in your CD, and you want to distribute it amongst your students, so that they have a CD copy with them, right? No problem, because I have taken the Creative Commons license. But please do not remove my name as the author of this particular work, right? Because I have taken the Creative Commons attribution license. That is, this particular person in the YouTube video has taken this license, CC BY license, attribution license. He has clearly mentioned here, please everybody note, Creative Commons attribution license, right? In the same way, let's say you're making a PPT. Okay, so you're making a PPT and you want to make use of some pictures that you find in Google search. So you are not sure whether you can use these pictures in your PPT. Let's say somebody has a coaching institute, they're making a PPT. Coaching institute means commercial purpose, etc., right? And you are supposed Googling, Tuscany images. So all these images, they come into place. So you are not sure whether you want to publish them or not. So what you can do is, along with after clicking images, go to the settings. In the settings, go to advanced search, and then you will see here the photographs which will be allowing you for non-commercial use. So some is labeled for reuse. It means that for commercial use also you can use it. But some photographs, it might be mentioned that you cannot use it for commercial purpose. You can only use it for non-commercial purpose. So, Creative Commons is everywhere, because at the end of it, to conclude in my lecture, I want to say that copyright is important. Why is copyright important? Copyright is important. Let's say if I write a book, if copyright is not there, if another person A takes my work, steals my work, and publishes the book in his name, I will feel very bad. I'll be feeling that it is unfair, because I have put my labor in creating it. So I will in future be very hesitant in publishing a book, because I feel that somebody can easily steal the work and publish it. So copyright has its own justification. But as we have seen in the Rameshwari photocopy case of Delhi University, it can also be a means to hinder education. That what are these publishers trying to do? They're trying to come and say that, please, you cannot give it, you cannot allow this photocopying. It's you cannot do that. It's infringement of our work. So if photocopying of those work is not allowed, most students studying in Delhi School of Economics will not be able to read these articles. So they will be hugely in disadvantageous position. So the balanced approach is the key. So let's say the Delhi High Court tomorrow decides on this particular case. Delhi High Court has to remember that we do not belong to the rich countries of the world. We belong to the poor countries of the world. We belong in the developing countries where our students cannot afford these kind of expensive books, right? So photocopying has to be allowed so that, right to education is a social justice, is accessible to everybody. Education is something which should be accessible for not just the elites, but it should be accessible for everybody, irrespective of which section of the society they belong to. With this, I would like to conclude my lecture, and I'll be open to any questions that you have. Thank you so much.
Thank you, ma'am. That was indeed a very enriching and enlightening and also thought-provoking session. Thank you so much. Before I open the house for discussion, I would like to give a brief outline of what ma'am has just presented, that copyright is a very important IPR and it includes those different kinds of subject matter. And it provides those monopoly right to the right holder to exploit their work to the exclusion of all others. But in the developing countries like India, where a vast majority are poor, it is difficult to get those copyrighted books. So in that scenario, is it all right that students and other readers be denied of these copyrighted books? So does copyright law working for the benefit of the society, or is it serving as a tool to divide the society by making books and other copyrighted works affordable and accessible only to few elites? Okay, this was what ma'am has presented. So with that, I will open the house for discussion. Questions are entertained. And ma'am, you may take on the discussion with the house.
Yes, please. Uh, I'm looking forward to having interactions with you.
Yes. Yes, any questions from the faculties or from the students? Please feel free to ask questions.
Ma'am,
Yes.
can you intervene? I have some doubts regarding the copyright.
Hmm.
Firstly, uh, can a copyright be sold? This is my first question. Yeah, suppose a publication company, I think maybe in India, we can assume it is Penguin or the finger point and such like that. Uh, Suppose the publication company published my book and I don't have any contributions on finance. So the publication company shall finance my uh, expenditure in publishing books. So uh, in that issue, who can claim the copyright? Me or the publishing company?
Right. Thank you, David, so much for the question. See, basically, what happens is how it works, I'll tell you. So, let's say I have written a book. I will, as the author of the book, the copyright first will remain with me. I will be the copyright owner, right? So, you were basically asking whether copyright can be sold or not, right? I will just take you back to one of the slides that I mentioned. I will just show you and I'll give you the answer to your question, right? So if you can see in this particular slide, I have mentioned about what are the rights that I will have as a copyright owner, right? So these are the rights that I'll have as a copyright owner: reproduce the work, issue copies of the work, etc., etc. Now what I am giving, so let's say a publisher comes to me and says that they want to publish my work. So the publisher once came to me and said that they want to issue, they want to publish my work. I can sell my copyright to them. When I allow the publisher to publish my work, I will enter into a contract with them, and under the contract I will enter into a licensing agreement with them, by which I will give them the license to issue copies of the work to the public, right? So it means that when I am allowing a publishing company to publish my book, I am giving a license to them to issue copies of the work to the public. So this is the right that I'm selling it to them. So yes, if I'm the copyright owner, I will be able to sell my copyright and earn money out of it. So David, is it clear?
Yes, Miss.
Yes.
Good evening, Miss.
Yes.
My name is Timothy Lalrindiki, and I'm currently from first semester student. I have one question regarding voluntary and compulsory licensing. And my question is, in case of compulsory licensing, does the copyright owner or patent owner lost rights or patent owner? And are there any remedies for copyright or any legal action and compulsory licensing?
Timothy, I'm very sorry. I think there's a network problem. I could not understand the later part of your question. Can you please repeat it?
Am I audible?
Yes, you're audible. You have to be a
Am I
little loud.
Yeah. In case of compulsory licensing, does the copyright or patent owner lose his rights as a copyright or patent owner? And are there any remedies for the copyright owner? And can he take any legal action against compulsory licensing?
Right, right. Thank you so much. I understood your question. See, compulsory licensing is very important. Please try to understand. Of course, you're absolutely right. Compulsory licensing is there not only in copyright, but it is there in case of patent also. But if for today's lecture, I was talking about compulsory licensing in terms of copyright. Okay. Now, see, compulsory licensing is not granted in a normal circumstances. Let's say there's a publisher of a book. I gave you the example in a situation that suppose there is a publisher of a mathematics book who has been publishing that book for 10 years. Now, that book is very important for class 10 board preparing students, right? Suddenly, the publisher is not publishing the books anymore, and the students who are preparing for their 10th class board exams suddenly do not have this book anywhere, right? Now, there is a book publisher who comes ahead and says that students are in panic. They do not have this particular book. The publisher of this book, the copyrighted publisher of this book, is not publishing the book. So, I want that tells the government that I want that please grant me a compulsory licensing. If you grant me a compulsory licensing, I will publish these books, and when I publish this particular book, I will make it affordable to the students, right? So this is not done in normal circumstances. It is done, compulsory licensing is given only in cases of public interest, where the public is suffering because an IPR object is not being accessible to them. Only then copyright compulsory licensing is granted. Now see, in case of compulsory licensing, usually there are a lot of terms and conditions that the government impose when they give the compulsory licensing. Let's say I said I am the publishing house who wants a compulsory licensing. And the government says, okay, publish the mathematics book because students need it. But the government will also give me a terms and conditions. And one of the terms and condition is that I have to pay some amount of money to the copyright actual publisher. So mandatorily, the government will say that this much of money do pay them, because they also needed to be given certain money out of it. Now, coming to your third question, can there be a legal action? No, it cannot. There cannot be a legal action because compulsory licensing is given by the government, right? So obviously, if you file a case against the government for compulsory licensing, first of all, the courts will not take cognizance of the matter, and of course, you will not be able to win the case because your matter will not be taken as compulsory licensing issued by the government. You cannot file a case against it. I hope, Timothy, I could answer all your questions.
Yeah, okay. Thank you, Miss.
Yeah, thank you. Anybody else?
Yes, is there any more who would like to ask questions to the resource person?
I think they are all tired because it's going to be 9 o'clock. It must be, I'm, cutting into their dinner time. Yes, David.
I want to ask more
Yes, please.
in regarding copyright issues. Well, I want to ask that if this copyright is valid, if an author did not have an ISBN in his book, in your slide, I know that you have mentioned that it is not compulsory for registration. The owner of the work remains owner if it is registered or not. But if we publish a book in India or in today's world, author mostly authors have uh, authors attempt to have ISBN in their books. So what is the point if registration is not compulsory? How how will the ISBN be an effective issues in such kinds of issues like that?
Okay. If I'm not mistaken, ISBN is for a different purpose, okay? And basically in academics, we want ISBN. I mean, I'm sure many of my fellow faculty members here would understand we need ISBN numbers for our API scores, right? So that's a very different thing altogether. So ISBN number is just a listing of books, right? But registration of copyright is with the copyright board, right? So the authority is very different. ISBN is a different process altogether. It has, in most probability, it has nothing to do with the registration of the copyright, right? And many books are also published without ISBN. Books are published with ISBN also, but registration of copyright is a very different question. The authorities are different, you know. So basically, when you get your copyright registered, you get a certificate stating that this is your copyrighted work and you are the owner of it. Now, let's say somebody is not interested. So they may not go for registration. But let's say we are law students, we are always aware about our rights and we are always fearful that somebody will take our work and remove our name as the author. So we always want to be in that safe arena, right? So we will always say that, no, we will register our work so that if tomorrow somebody takes our work, we can file a case against them. So this certificate of registration will be like an evidence. But ISBN is a different thing altogether. ISBN, different thing, different mechanism. You know, registration of copyright, a complete different authority, a complete different dimension altogether. Not really interrelated between the two. But
Okay, thank you, ma'am.
Yeah.
Yes, it is almost 9, and I think it's already 1.5 hour session, and the resource person might be exhausted. So I will entertain one last question. Is there any more question from the participants?
Yes, ma'am. I have one question.
Okay, one last question, okay, for tonight.
Okay. My question is, thank you, ma'am. My question is regarding the translation. For example, there are so many translation here in our locality into Mizo language or into Indian language from the books of Western or from the other countries. In their translation, they don't have the permission from the authors. So in this case, can they sue us from the foreign country for illegally translating their books?
Right. Of course, they can sue you, right? If they want to. If there's a copyright, they can sue you, definitely, because you're translating without your permission. But usually what happens, I'll tell you, most of the books that you get easy translations, it's because, you know, the copyright is over. Let's say Shakespeare died in 1800s. The copyright is over before 1900. So if you are translating, let's say, William Shakespeare's work in Mizo, there is no question about copyright infringement because the copyright is over, right? So in my case, as I told you, let's say I die in 2032 and then copyright exists in 2092. So from 2092 onwards, if somebody writes or publishes my work, I will have no problem. There will be no copyright issue because my copyright term will be over, right? So I think you know Rabindranath Tagore, right? Rabindranath Tagore expired somewhere in 1940s, 1946, let's say. So 1946, when he expired, all his poems had a copyright for another 60 years. That was, let's say, till 2006. So after 2006, so if somebody is publishing books as Rabindranath Tagore's book, there is no question of copyright infringement. Now, there are a lot of television serials which are made, web series which are made in Netflix based on Rabindranath Tagore's stories. There is no question of copyright infringement because his copyright is over by 2006 after 60 years of his death. So most translation which you might be finding will be of work where copyright is over. But if there is a translation happening where the copyright is still there, then of course it's a matter of infringement if you are not taking the permission. I hope I could satisfy your
I
question.
think,
The answer
yes,
is
the response is quite clear. I hope Vanepuya is clear with the response.
Yes, ma'am. Thank
Yes,
you.
yes. Okay, with that, I will close the house for discussion. Indeed, it is a very enriching session. So now I will call upon Mrs. Zoparliani Khiangte to propose a vote of thanks.
Thank you, Madam Chairperson, for giving me an opportunity to convey my gratitude on behalf of IQSC and Special Academic Committee, Government Mizoram Law College. First and foremost, my sincere gratitude to the Almighty God for giving us a good opportunity tonight. While many people cannot have this kind of opportunity, if we all aware that like the war is going on the other side of this world, so like we should appreciate that, I guess. And secondly, I like to thank our resource person, uh, Dr. Jupi Gogoi, for taking her precious time out for us and sharing her rich and experience for us and accepting our humble request and being a friend to Madam Rebecca also. And thirdly, I like to thank the organizer for putting this program together for all of us so that we can learn and enrich ourselves in this subject. And I am sure that like the student will be more aware or much aware after this program. And last but not the least, my sincere gratitude to all the wonderful audience, because without your participation, this program won't be a success. And patiently waiting till the end. And once again, thank you, everyone, and have a very good night to you all.
Thank you, Mrs. Zoparliani. It was very last minute that we asked her to propose a vote of thanks. It was supposed to be the principal, Dr. Walkuma, Professor Walkuma Kolni, but due to some works in the college, last minute, he could not make it tonight. I also thank the principal for his support for organizing this webinar. And I kindly request all the participants to fill the feedback which is provided in the chat box. And after this, just after this, we will have a photo session with the resource person. So I request every one of you to open your video for the photo session. Yes, it is undeniably tonight we all benefited from this presentation, and I'm sure that we all have gained something from tonight. Thank you all. I thank you all with a grateful and indebted heart to all for your participation. And with that note, we came to the end of tonight's webinar. Thank you, everyone.